Welcome to this presentation relating to race and color discrimination. As usual, I would recommend that you pull up the PowerPoint or the study guide and kind of read along as we cover the material in those guides, taking careful notes when I add additional information to what's available on the PowerPoint. You'll see in this version of the PowerPoint compared to the version you have that I've put in some text into italics. Those are items that before I while I was preparing this lecture, I thought were especially helpful or appropriate for more focus. So they're kind of my notes, but since it's what I'm going to be emphasizing, it may be helpful for you to also note that material. So let's begin. These are the topics that we're going to cover in this presentation. We're going to briefly touch on the history, a little bit about the topic of what does race mean, and then we're going to discuss the topic of racial discrimination. A little bit on disparate treatment, but also some on disparate impact, and also racial discrimination bias or associational racial discrimination. We'll talk briefly on racial harassment, and then we'll talk about sections 1981 and 1983. And finally, we'll talk briefly about color discrimination. So let's begin. You can't have been in the United States for very long without realizing that we have a very difficult and sad history of racial discrimination in our country, obviously stemming back to the very founding of our country. And unfortunately, many of the abuses have continued into modern times. Certainly many of the worst forms of abuse have ended or become much less prevalent, but still these problems in many forms continue. One thing I'd like to draw your attention to is something after the Civil War ended, but back in the 1900s, early 1900s, there were laws called Jim Crow laws. And these laws legalized and codified racial discrimination by keeping the races separate and by keeping African Americans in a disadvantageous position. And so if you hear the term Jim Crow, that's what we're referring to when people talk about those particular laws. Obviously, those laws are no longer in effect, but it doesn't mean that the repercussions of those laws don't continue to affect number one, the net worth of African American families in terms of their financial net worth, where people live in a particular city. All of those things, in many cases, can be attributed to some extent back to this segregation history that our country has had, and in some senses continues to have. A really important case in our history is Brown v. Board of Education. Thurgood Marshall, who eventually became a U.S. Supreme Court Justice, was the attorney who argued it for the NAACP, and the decision issued in 1954. It did not immediately go into effect because the school systems were allowed some time to desegregate or integrate. Unfortunately, many schools waited a considerable amount of time before that happened. One of the more famous schools to have integration was Central High in Little Rock, and I believe that happened in 1957 or 1958. And in fact, the students who were willing to be integrated, the African American students, received a very, very, very difficult reaction by the community and by the other students. Very brave, I think they were women who were in that position. And as a result of those trailblazers, now of course we have integrated schools. Doesn't mean that all schools are equal across our country and that race isn't a limiter in because of patterns of living, but certainly de jure or legalized desegregation no longer exists in our country, even though there continues to be some de facto discrimination because of socioeconomic levels. And of course, you can't talk about racial discrimination in the United States without talking about the Civil Rights Act of 1964, which is the Title VII that we've been talking about throughout our course. Okay, of course, racism isn't over. We still have it. We've made strides, but certainly there are definitely continuing opportunities in this area. Another interesting thing about race is that the idea of race is really something that has evolved over time. The idea of race is much more of a social or cultural construct than a scientific concept. There is no gene that determines whether I'm of this race or that race. In fact, it's rather difficult for a scientist who's looking at a bit of my blood to be able to decide what my racial identification might be. And so it's more of a cultural idea, but that doesn't mean it's not important. It is certainly a basic fact that Americans know about themselves, and it causes a reaction that we have towards one another that can be positive or it can be negative. At different times in our history, people who speak the English language have meant different things by race. There were times where a person might say that an Irishman was of a different race than, say, an Englishman, or a person who was Jewish was of a different race than a person who was Christian. We would think, well, that's silly. An Irish person is Caucasian or white, just like an English person is. And a Jewish person, especially a Jewish person whose ancestors are from Europe, is definitely white, just like a Polish person or a German person might be. So again, this reflects a different meaning for the term race. And that's kind of a useful thing as we're thinking through these issues, to recognize that this is a term that can mean different things. Sometimes when race is raised in a discrimination case, it's really restricted just to the topic of race. But more than half, I'll put it this way, more than half of charging parties are likely to advance other theories other than just one. After all, there's really no downside to them to advancing multiple theories. If they fail to advance a particular theory, and yet as the facts develop, it seems like that might have been what was really going on, they may have waived that issue. So the inclination, and it's a smart one on the part of the charging party, is to allege as many theories as they can kind of reasonably think about. Keep in mind that when charging parties file their charge of discrimination, in most cases, they feel like something has been done wrong to them, but they're not quite sure what, because it's pretty rare that somebody says, "Hey, Bob, I'm firing you today because you are African American, or you are of Chinese ancestry," or something like that. Even the most ignorant, bigoted person is probably not going to say that. They'll have some other reason that they fired Bob, that they give to Bob. But Bob is thinking, this doesn't feel right. I think there was another motive. And Bob may think it's his race, and maybe that is what it is. Or maybe it's some other thing about him. Maybe it's his religion. Maybe it's his gender. Maybe it's his politics. Maybe it's his other characteristic about him. And so it's a smart idea for the charging party to identify as many different categories as possible. And sometimes there is an intersection. For example, you might have a charging party who's from the Dominican Republic. He might identify culturally as Hispanic. He might identify as national origin as being Dominican, and he might identify racially as of African ancestry. And so you can see how all three of those kind of intersect. And a particular employer might have a very good rapport with African Americans in the workplace, or then maybe that employer has a really good rapport with Hispanic workers in the workplace. But for this particular candidate, having those three things intersecting might somehow cause there to be different dynamics in the relationship. You might call this, just like we talked about sex plus when we were talking about, say a woman who is also a caregiver of preschool children. We call that a sex plus claim. We can also have a race plus claim, certainly when more than one factor is contributing to the bias that that person is experiencing. We've talked about the glass ceiling before, but certainly it applies. When people talk about the glass ceiling, they usually talk about it in terms of Caucasian women. Why haven't Caucasian women made more strides? But an equally valid perspective is, well, why haven't African Americans made more strides in the workplace? Or why haven't African American women made more strides in the workplace in terms of climbing the ladder? What are the barriers that are stopping that from happening? So the glass ceiling concept is not restricted to gender by any means. The EEOC has recently developed an initiative called E-Race. The reality is that while there's lots of different categories of employment discrimination, race continues to be by far the most common charge filed. And it has been pretty much forever, and there's really no indication that's going to change. There's been changes in the number. For example, national origin claims, religion claims have increased in recent years, to some extent due to a 9/11 fallout, but race continues to be a really, really important category. As you can see here in 2010, 36% of all charges were based upon race. So that just gives a little bit of an overview of what we're talking about when we talk about race discrimination. We've kind of already talked a little bit about what is race, but let's just think a little bit, not so much from the sociological or the scientific perspective, but let's consider it from the perspective of the law. What do we mean? And there are several terms that kind of come together. One is national origin. Certainly, if my national origin is Kenyan, for example, or Sudanese, it's very likely that I will identify as of African descent. And I may have an accent that is identified as of African descent. I may have an appearance that people identify as having an African descent. For example, darker skin, darker hair, dark eyes, those types of things. So you could say in that situation, national origin is pretty closely related to race, but they can be different concepts as well. Let's look here and kind of unpack the term national origin. National origin is the country or place from which a person or at least some of his ancestors originated. So my national origin, I was born in Brazoria County, Texas. My national origin is the United States. But I don't, as far as I know, have any Native American ancestors. So all of my ancestors at some point lived elsewhere in the world. I don't know everywhere they came from, but some of them came from Scotland, some came from Ireland, some came from France, some came from Germany. Also, it seems likely some came from Spain and probably other places too. So my national origin would include all of those places that my ancestors came from, as well as my particular ancestry. Let's imagine Bob. Bob was born in Peru. But Bob's ancestors, his mom and dad, actually were born in Hungary. Maybe they immigrated during that brief period of time in the 1950s where Hungary was not under so strong control of the Soviet Union. And I think a fair number of Hungarians were able to escape. Let's also assume that Bob's parents were Jewish people. So under those circumstances, Bob is ethnically Jewish. He will say in our example, he's converted to Catholicism, so he's religiously Christian. He is ethnically Hungarian, so Eastern European, and he is culturally Peruvian, Latin American. You can see how his national origin reflects lots of different groups going on there. And he doesn't have to pick one. He doesn't have to say, well, I'm Peruvian, and that's the only thing I can be. No, he can be Peruvian and Hungarian. He can be an Ashkenazi Jew. He can reflect all of those aspects in his national origin. Maybe his mom was from Hungary. His dad was from Argentina. Well, then he would have both Argentinian ancestry and Hungarian ancestry. National origin discrimination, of course, means that we're treating somebody less well just because of the origin that he or she is from. It's, of course, not considered national origin discrimination for me to discriminate against Bob because Bob doesn't come to work on time. That's not having anything to do with his national origin. Now, let's assume that Bob originally comes from country X. And let's say there's even a stereotype that people have about people from country X, that people from country X just aren't good about arriving at time, that the culture overall has, that people are tending to be tardy for things. Well, if Bob is prompt to work and he is discriminated against because people assume, well, somebody from country X is always late to meetings, and so we're not going to hire Bob, or we're not going to trust him with the big project because we think he's going to be late to meetings, then that's national origin discrimination. But it's not national origin discrimination if Bob actually is late to meetings, because he's being disciplined because of the actual output that he has. So the cultural stereotypes that might exist, if the employer isn't basing his decision on it, that would not qualify as national origin discrimination. Here's an example, national origin discrimination. Bob is often ill-treated at work because his mother is Estonian. That would be an example. Probably not too likely, but maybe that could happen. Okay, so that's what national origin discrimination is about. You can see that national origin does not necessarily track with race. For example, there's a famous chef who is from one of the Scandinavian countries. I want to say Sweden. I could be mistaken. He was adopted by a Swedish family, but he was actually born in Africa. And so he doesn't look like our stereotype of what a Swede looks like. So he would have two national origins. He would have the place where he was actually born, where his biological parents were, but he would also have the national origin of Sweden if he, in fact, was filing some kind of claim. And so national origin does not necessarily track with race. Color discrimination is just what it says. It's about the tone of the skin. So again, within a racial or ethnic group, there can be a great deal of variation. Some of it may be genetic. For example, some people just have darker skin, even within a racial group. Sometimes it may have to do with the amount of sun exposure that a particular person has. It can also reflect, or can be influenced by the degree to which this person has multiple cultures. So for example, a person who has different ancestry may be having some ancestors who have relatively light skins and some ancestors that have relatively dark skin. That particular person might have, a skin tone anywhere along that continuum, and that could be the result that happens. In some cultures, lighter skin tone is more preferred. That some people think is attributed to the colonization and oppression that Europeans have, and Americans for that matter, have inflicted upon various parts of the world, that people started thinking, well, the Europeans and the Americans, who usually had relatively light skin tones, they were the people that had the money, they were the people that had the perks, and therefore it's good to look more like these wealthy people than maybe the way that historically my community has appeared. And so that is perhaps one reason that exists. But whatever the reason, it's unlawful. So let's imagine that you have two people from a particular national origin, and one person has darker skin and one person has lighter skin. They're both part of the same community, so it's unlikely that one would discriminate against the other based upon national origin. They're both part of the same racial group, so it wouldn't really make a lot of sense for one person to discriminate against the other based upon the race, since they share that. But color discrimination can and sometimes does happen within people of the same race and national origin, so that someone who has a darker skin tone may be discriminated against. And it can work the other way too. People with lighter skin tones can be subject to discrimination as well. Okay, so let's go in and talk about race. The first thing to note is that race is not defined in Title VII. So we don't have a statutory definition. can say a few things about it. First of all, being American isn't a racial identification because there are Americans of every race. And so that would not be, unless we're talking about Native Americans, and then in that sense you could say that that is a national origin or possibly an ethnic group. But that's in a country, a citizenship. Maybe it's certainly a national origin, but it's not a race. Asian would be a race, or more specifically, Vietnamese or Laotian or Chinese. Or Indian, those would be racial groups. White or Caucasian would be a racial group. African, Black, African American, those terms would also be identifiable as racial groups. These terms oftentimes have very loaded meanings associated with them that can be controversial and can be hurtful. And so it's a good idea when you're talking with people in particular categories that you be very sensitive to what the person with whom you're speaking prefers. There are many people who strongly prefer African American to Black or a different term, but then there are some people who prefer Black to African American. If you encounter a person who isn't an American citizen, maybe somebody who's originally from Africa, it wouldn't be appropriate to call them African American, but just to call them African or perhaps Black, for example. So it's good to kind of think through some of those issues to make sure that you're being sensitive and listen to the person. See where they are on that continuum. These terms also change over time. Terms that might have been acceptable 20 or 30 years ago and completely inoffensive at the time can become offensive. And terms that might have been rather offensive at an earlier time can cease to be offensive. So it's useful to stay abreast of these issues and ask people what they prefer. As we said before, race is a socio-political concept. It's not about biology. So we've talked about what race and national origin and color means under Title VII, but let's talk about it under 1981. 1981, again, is that Reconstruction era law that was passed in 1866. And it was again designed to assist African American former slaves who, for the most part, were still living in the South and oftentimes were very, very oppressed. Yes, they were no longer technically slaves, but in many situations, their circumstances had improved very little. And so this was a way to address this via federal statute, because obviously the states in the South were not on their own going to address these issues. 1981, Section 1981 has been defined to really be focused on race, not including national origin. It definitely doesn't include things like gender or religion or age or disability. And so as you're thinking about Section 1981 claims, we're really going to focus on the racial component. Okay, so let's continue on. We've talked about the history. We've talked about what do we mean when we talk about race. Now let's talk about really why we've come to this particular slide, racial discrimination. As I said before, the primary focus of Title VII employment discrimination protections were on the African American community, because race was seen as the motivation behind the Civil Rights Act of 1964. And while other groups ultimately were protected, certainly if you were to have asked the Congress people and the president at that time, what is this law about? Virtually all of them would have said race. That's what we're really focusing on. In addition to racial discrimination claims, though, we also have the possibility of retaliation in a racial situation and harassment. Let's look at an example to unpack what we're talking about. So we have Bob. He's a Caucasian manager. He'd like to promote Mary, who's an African-American waitress in the restaurant. He'd like to promote her to assistant manager because she's very efficient and productive and a good worker. But the owner of the restaurant is racially biased, and that owner does not want Bob to promote Mary. Bob is very, very frustrated because he knows she would be the best for that particular role, so he promotes her anyway. As a result of Bob's insubordination to the owner, Bob gets fired. Under those circumstances, if Bob can prove that he was fired because or that the owner prohibited the promotion because Mary is African American, not because of the quality of her work. And it can also prove that the owner fired Bob because of Bob's support of Mary. Then Bob has a good claim for retaliatory discharge under Title VII. It's not a requirement that Bob actually be African American. He can have a claim for retaliation in a racial discrimination case because his race is irrelevant. The important thing is that Mary was the victim of racial harassment and Bob was assisting her in either, in this case, not being a fact witness, but actually doing the right things in terms of employment. The vast majority of race cases are disparate treatment. I mean, this is the classic scenario where somebody is denied a promotion, terminated, not hired simply because of his or her race. And it doesn't require really that, or really in any sense, it doesn't require that the person making the decision has to be consciously aware of the racism that he or she has. Much of the racism that we have, and most of us are not completely free, unfortunately, from assumptions about people from different races and socioeconomic and national origin groups. So when a person comes to the workplace, they don't leave that behind. Even if they really want to, they come with certain assumptions about this group or that group. And so they may be being completely sincere when they say, I didn't fire Bob because he's African American. They really believe that. And yet if Bob had been of Japanese ancestry, or if Bob had been of German ancestry, very possibly that employer would not have fired Bob. So you can have disparate treatment even when the person engaging in the disparate treatment is unaware of the true motivation. In addition to disparate treatment claims, though, we also have disparate impact theories. So if you have a rule that negatively impacts African Americans, even if it's facially neutral, then that's going to raise all those disparate impact theories that we've discussed before. Usually there aren't issues about height or weight that are related to the African American community like we saw with gender issues. An example where we might see a disparate impact situation was when we were talking about the fact that some African American men have a skin condition where if they are clean shaven, the beard hairs can become ingrown when they do grow a little bit, and that results in a condition that is somewhat disfiguring and also painful for the man. And so as a result, men who have this illness or this condition will have facial hair. So if you have an employer that has a facially neutral policy that says no facial hair for men and doesn't make an exception for that relatively small part of the African American community that has this condition, then there could be a disparate impact claim under those circumstances. That's just one example of disparate impact in the racial context. Discrimination against an individual because of the perception of his or her race is a violation, even if the perception is incorrect. So let's imagine that there were an individual, say, from the Middle East who, we'll say the Middle East, who had relatively dark skin and dark hair. That person might be mistaken for maybe somebody who has African American ancestry. And so they might be subject to discrimination as a result of that. And let's say as the case progresses, it comes to everyone's attention that in fact this person isn't African American. Well, their true race really is irrelevant. If they were treated disadvantageously because of a protected characteristic that the employer thought they had, then they can successfully advance a Title VII claim. Let's consider this scenario. Bob employs a large group of Hispanic employees, and there's no reason to believe, no one thinks that Bob discriminates against Hispanic employees. Bob denies Susan a job because he thinks she's a light-skinned African American. In fact, Susan is Hispanic. Bob ordinarily doesn't discriminate against Hispanic people, but he does. He's racially, he does discriminate against African Americans. And so because Bob misidentifies Susan, Bob has violated Title VII with respect to Susan. Sometimes, every category of discrimination kind of has its unique issues. And in the area of race, some of those things that come up are the symbols and the terms that are especially offensive and symbolic within the history that we have in our country on these issues. For example, a noose is a very fraught symbol for in the racial front. So, leaving a noose, for example, on the desk of an African American would suggest that this person is in very significant peril, because it reminds the African American of the history that exists in the United States of African Americans being lynched or basically hung outside of a judicial process, maybe being completely innocent of any crime. So that symbol, in some sense, looks innocent enough, and if you don't know the history, you might not realize how significant that is. But in the context, it is a very, very disturbing symbol. Also, terminology, especially used in ways to demean and to denigrate African Americans. Those terms are also very, very loaded and can be a source of a great deal of turmoil in the workplace. Okay, so when we're looking at a race discrimination case, we have that same prima facie case framework that we were talking about in the McDonnell-Douglas case. Let's just reflect on the 4 aspects of the prima facie case. First of all, the plaintiff has to prove that he or she is a member of a protected class. Well, everybody's a member of some race. Many of us are members of more than one race, so that one's pretty easy to make. The second thing that the plaintiff has to prove is that he or she was qualified for the position. In most of these cases, the person is already in the job, and most race claims are termination cases. So the person was already in the job, so in most cases, it's pretty obvious that they were in fact qualified for the job. The third thing that the plaintiff has to prove is that there was some kind of adverse action taken against him or her. Being terminated is clearly an adverse action. So that one's usually very easy to prove. The fourth is the most vaguely stated, and that is that there has to be at least one more piece of evidence that points to the fact that there could be racial discrimination. The most common piece that is used is when the African American is replaced by someone of a different race. That's not the only type of evidence that can be used, but that's the most common. And so usually it's pretty easy for an African American to make that prima facie case standard. You may recall, though, that once the plaintiff has made that prima facie case standard, the defendant gets to present business reasons why, non-discriminatory business reasons why that action was taken. So let's say Bob was fired. He's African American. He was replaced by Ted, who is Caucasian. So Bob has made the prima facie case. The employer comes back and says, well, Bob was late to work 7 days in a row, and our policy is we always fire at this point, and we've been consistent in firing every single time in this case. Well, that's a pretty strong case that the employer is making to rebut the prima facie case. But then Bob could come back and he could present evidence that shows it's pretext. Maybe the employer's mistaken and there were some exceptions. There was a couple of Caucasians who had bad attendance and they were retained. That would undermine the argument. So there's that 3. After you find the prima facie case, there's those 2 steps after that. In addition to the prima facie case framework, the McDonnell-Douglas framework, of course, the plaintiff can also present direct evidence. Examples of direct evidence would be things like this, the calling of names, other things that seem clearly to point to racial discrimination. We'll actually look at an example of name calling as we advance in this PowerPoint. In any kind of employment discrimination case, and really any kind of case that gets in through our legal system, the ultimate burden of persuasion to the jury is always going to reside with the plaintiff, and that is also true with race discrimination cases. So let's consider Mary's situation. Mary's an African-American woman. She's worked for her employer for 5 years. A position opens, Mary applies, but Deborah, a white woman, is the one who receives the job. Deborah actually has better qualifications than Mary. Mary files a racial discrimination claim. Under these facts, Mary's claim won't prevail because Deborah's promotion was not due to racial bias. But let's notice that Mary can make the prima facie case. Okay, let's go through it and look at Mary's circumstances. Well, Mary is African American, so she's a member of a protected group. It seems like she was qualified for the job. She's working in this place. We'll assume that she was qualified for as a higher job, but since she applied, we'll assume that she would be able to show that she was qualified for the job. She did not receive the job, so she had an adverse impact. And the person who got the job was of a different race. So the prima facie case was satisfied. It just so happens in this case, the employer can show that Deborah had better qualifications. And so therefore, the employer is going to be able to win on kind of that next ground. Racial discrimination is prohibited against any racial group. So Caucasians are protected, African Americans are protected, any racial group would be protected under this law. As always, really in any category, poor job performance is a legitimate non-discriminatory reason for dismissal. Now, it's always good to be as concrete as you can with job performance. So what you don't want to have when you are trying to demonstrate that you made the correct decision in terminating someone, for example, is you want to avoid things like Bob had a bad attitude. Bob always was sulking. Bob never seemed to come up with any ideas. You want to be concrete. You want to be able to show, well, Bob missed these 4 deadlines, and nobody else in the department missed as many as 4 deadlines. Or Bob was only given 30% as many cases, and yet he wasn't able to get as many of them closed as the other workers or whatever. You can't always make things that quantifiable, but to the extent that you can, you want to be able to do so. And it's always a good idea if you're the HR person and you have a manager, and this manager is wanting to move towards termination for Bob, you'll want to see, well, how is the manager interacting with other people who happen to share Bob's characteristics? How does this manager react to men generally? How does this manager react to other African Americans in the workplace? To make sure that this manager doesn't just have a problem with one of Bob's protected characteristics. If an employer institutes an affirmative action plan, and let's assume the affirmative action plan was well designed to pass judicial scrutiny, and let's assume the employer complies with that action plan. Under those circumstances, the employer is not going to be liable for any kind of reverse discrimination claims that Caucasians might be able to advance or men might be able to advance. It's a delicate thing to develop a lawful affirmative action plan. We talk about that in another module, but that's a little bit of an exception, or at least a different emphasis when we talk about racial discrimination, because it is possible to have, if you have an affirmative action plan, ways in which you are emphasizing a different portion or different skill set within the population. If an employer doesn't have an affirmative action plan, the employer can't prefer people of a particular race. So that's something to keep in mind. They are less common these days than they were at one point. So you may work with them and of course, if you are a government contractor, you very likely have an affirmative action plan, but they're probably less common with private employers who don't have government contracts. We already talked about opposition activity. This is the same thing as retaliation. Someone who opposes the law. We were talking about Bob, the restaurant manager. He opposed the owner's discrimination against Mary. So you can call that retaliation, or you can call it oppositional behavior. But either way, Title VII prohibits it. Let's consider Juan. Juan is a chemical engineer. He's the only Dominican employee in his department. Juan identifies as culturally Hispanic and racially as African. He's terminated after 10 months on the job because of poor job performance. The supervisor says Juan continued to be the least productive employee in the department in spite of frequent feedback and training given to him. Juan thinks he has a good claim for discrimination because he's the only Hispanic in the department. If the employer can prove that Juan was really the least productive person and that Juan was given frequent feedback and training, then the employer is likely to prevail in the case. On the other hand, if the employer can't substantiate those things, then Juan may not be successful in his claim. But obviously, poor job performance is a legitimate non-discriminatory reason to take an action against somebody. So the statutes that we think about when we're talking about race would be Title VII of the Civil Rights Act of 1964. We also have Section 1981, Section 1983, and this is the Affirmative Action Executive Order. We've already said this before, but Title VII and also Section 1981 prohibits racial discrimination against all people, including Caucasians. Let's consider a scenario here. Mary is a white person and Bob is an African American person. They work in the same place. They together decide to steal some things from the store. Mary watches the front while Bob loads the beer in his back. Unfortunately for them, they're maybe not the most observant because they don't see the security cameras. The owner of the mart is informed about the theft, and he decides to fire Mary but gives Bob a written warning. Well, because the same action wasn't taken against the two people, and yet they were both very involved in the activities, except in a certain respect, I guess you could say Bob, I wouldn't say his activity was worse, but certainly wasn't any least bad. Then under these circumstances, the owner appears to be treating Mary more harshly than Bob. Now, there could be lots of reasons for that. It could be that Bob had been employee for 20 years and Mary was employed 3 months ago. Or it could have been that Mary had already been caught stealing before and had been given a warning. So there's possibilities of no more facts there, but if these are all the facts that exist, it certainly seems as if Mary would have a claim for discrimination under Title VII. Now you might be thinking to yourself, well, gosh, how can somebody who's stealing from her employer be able to successfully sue the employer? And you're absolutely right that this Eager Beaver Mart would be completely within its rights to fire both workers when they have been involved in theft. That would definitely be a non-discriminatory reason to fire both. But when you choose to make distinctions and retain one and not retain the other, you face the possibility of it being interpreted as some type of discrimination, especially if the two individuals have protected characteristics that are different. You could also look at this and say, well, maybe it's a sexism. Maybe Bob was retained because Bob is a male and Mary was let go because she's a female. So there's different ways of approaching that. This is a fact pattern. I'm not going to spend a lot of time on it because the case is in and of itself not an important case. In this situation, Ms. McCullough was put in a position, she was denied a promotion, and the person who was promoted was significantly less qualified. And the question is, did Ms. McCullough present enough facts to get to the jury? And the court found yes. It was permissible to assume the reason for the decision was unlawful because, after all, Ms. McCullough was a college-educated person. The person who was promoted had only a 6th grade education, no prior job experience. Now, again, it's possible that the company would be able to present some reasons. For example, perhaps when Ms. Craven was hired, she was incredibly more productive than Ms. McCullough was. You know, there could be reasons to justify it, but certainly on paper, it looks like kind of a crazy decision to promote Ms. Craven over Ms. McCullough, given the fact that Ms. Craven's work experience was significantly less impressive. So I'm not talking about this case as being a significant legal precedent. It's just a good example of how the law is developed. You don't need to know the name of this case or the particular facts. Okay, this is one that has a racial epithet in it. In this case, this would go to the U.S. Supreme Court. In this case, adult men were referred to as boy. And the question is, was the use of boy racially motivated? And the court held that yes, that could easily be an interpretation, that the name calling was evidence of an intent to racially discriminate. And so the plaintiffs were able to have the case remanded back to the trial court, saying that these racially offensive terms, epithets, could be evidence of discriminatory intent. In this particular case, though, it didn't actually help the plaintiffs, because when it was remanded to the trial court found that no, there was no racial animus or intent to discriminate in this particular fact pattern. So that wasn't ultimately helpful, but the idea that the precedent is important. Names matter. What we call each other does matter. And training your managers and supervisors and coworkers to speak respectfully to others, sensitively to others, is just a smart plan. It reduces legal exposure, and it creates a much more pleasant work environment for everyone. So these are finger curls. Finger curls are a fashion style. Certainly African Americans have worn this fashion style for many years, as well as Caucasians. So while it may be identified for many of us as a hairstyle with deep ties to the African American community, it's not unique to that part. In this particular case, the employee was wearing the finger waves or finger curls, and her supervisor said her hair was too different. It was drawing too much attention, that she needed to change it. But her hair was not technically violating the grooming standards in this place of employment. We've talked before about how grooming standards are usually not a very helpful tool for plaintiffs to use to establish, gender discrimination or national origin discrimination or race discrimination or something like that. But this is one of those cases that actually was successful. The court said, I'm sorry. The Court of Appeals also held that Rollins' evidence of disparate treatment against her as an African American was sufficient to rebut Atlantic's dress code defense and permit a fact finder to infer unlawful discrimination. But let's see, there was something about, maybe there isn't. Anyway, so you can see, I guess the takeaway here is that you can see that grooming standards are not a carte blanche for employers, that you ought to be sensitive to the cultures and individual expressiveness of folks. So if you are going to limit a person's expression, obviously you're always concerned about issues of safety and things along those lines. And if somebody is customer facing, that's another thing to consider. Is this going to tick off or offend potential customers? But in this particular case, I think that Ms. Hollins was perhaps in a manufacturing. She was a machine operator. She wasn't dealing with the public generally. And so it's a little hard to know how her finger curls were causing her not to be able to perform her job well. And so having unnecessary rules probably isn't the best business model. Okay, let's consider Rashid Olson. He's an African-American man with a bachelor's degree. He applies for a job, and he also has a friend who has the same qualifications. His friend is white. His friend gets an interview call, but Rashid doesn't. So Rashid thinks to himself, maybe my first name caused the gym not to want to interview me because they figured out I'm probably African-American. So he submits the same resume again. This time he calls himself Bob Olson. He is granted an interview. Under these circumstances, it's pretty clear that he has been the victim of racial discrimination. And so you could call this racial perception discrimination. This is definitely a real thing. There have been many studies that show that people who have names that are generally associated with the African American community are less likely to get interviews. And there's something that every HR person and everyone working in legal industry in this area ought to be aware of. And so it can be a good idea in your place of employment, maybe not to share the first name with individuals, maybe just to reduce it to a T. So maybe if you're in HR, instead of presenting Rashid Olson's resume to the hiring person, you should have presented it as R. Olson. So to remove the likelihood of that type of discrimination. Now, obviously, you'd want to share the name for the interview because, you know, you don't want to not know the person's name when you're talking to them. So keep that in mind, that this is a factor that can influence, and again, it's probably unconscious. Probably the person in the gym didn't consciously say or think to himself, wow, this name is African American. Well, I don't like African Americans, so I don't care how awesome he is. I'm not going to interview him. That's probably not the thought process that gym person went through. But obviously, on some level, there were some prejudgments about somebody, that someone named Rashid Olson wasn't quite as qualified for the job as someone named Bob Olson would be. Let's talk about BFOQs. We've talked about this in the context of sex discrimination and religious discrimination. The good news for us is that it's easy for BFOQs in the race area. You just can't have them. They are not permitted. You definitely can't have a bona fide occupational qualification reflecting customer or coworker preference. After all, isn't that the problem behind racial discrimination? The reason why employers oftentimes don't want to hire African Americans is because they are concerned that the general public won't be as satisfied buying a car from an African American or having their knees stitched by an African American. And so if we allow biased customers to dictate what businesses who they hire, then we're just going to replicate that system of discrimination. So you cannot have a BFOQ for race. Now I'm going to say that's true, and that would definitely be the answer on any test question. I would, however, say that if somebody were doing a movie about Martin Luther King, it would be pretty strange to put a Caucasian person in the role of Martin Luther King or a Korean person in the position of Martin Luther King. So in theatrical roles, I would say that, you know, having a preference for people of a particular race when the race of that person is an important factor in who they are, I don't think too many courts would find that offensive, because it's really a fairly reasonable interpretation. But most of us aren't in the theater business, so that's not really where we're going to see the actions. Most of us in just ordinary commerce should not entertain the idea of a BFOQ relating to race. Let's talk about residency requirements. This comes up a lot of times. Fire departments or police departments will want to hire, or at least give preference to people that live in the community. And that's not problematic if you are in the city of Dallas or the city of Fort Worth. It's really not even problematic in Plano and Richardson and Frisco. But you can imagine parts of the country, actually, an example here would be Highland Park. My guess is that the percentage of people in Highland Park who are African American is relatively low. And so if Highland Park were to restrict the people who could successfully become police officers and firefighters in their community, they would have a relatively small population of African Americans to draw from. And so when you have, and this oftentimes happens when the community is a very high income community, or if it's in a relatively isolated place where, for whatever reason, people of certain ethnicities have grouped for cultural or other reasons. Those rules can be problematic, and of course you can't really have residency requirements unless you're a governmental entity, and that would be very, very difficult to defend. If, for example, if Toyota decided they were only going to hire people who live in Collin County, well, what would be the possible motive for that? There wouldn't be one. And so a government entity perhaps can entertain that, but needs to be aware that it could create a disparate impact situation that could be unlawful. So Title VII's racial discrimination prohibition relates to, obviously, ancestry. That's usually what we think about when we talk about race discrimination. When we identify someone as a member of a race because their ancestors once were in that part of the world. Then this can also be related to physical characteristics. Certain differences in appearance obviously track with race. People from Europe might have pointy noses, might tend to have paler skin, might tend to have thinner hair, maybe of a lighter shade. Those would be physical characteristics. And so for an employer to prefer, this type of nose or this type of skin color would be an example of race discrimination. Here's another category, though, that it kind of crosses the line. This would fit into that race plus category that we were talking about before. There are certain illnesses that are related to certain racial groups. For example, sickle cell anemia. Sickle cell anemia is a very serious and painful disease. It's not restricted to people whose ancestors are from Africa. There are people in other parts of the world that have had sickle cell. It's actually a body's response to, it's a mechanism some bodies have developed to kind of counteract the harmful effects of malaria. So places where you see sickle cell anemia are also places that have a significant problem with malaria, at least over, in the past. They may not currently have it. And places that have problems with malaria are places that, are swampy and hot, and so typically are around the kind of equator area. Those places are obviously in Africa, and so people whose ancestors are from Africa are more likely to have sickle cell. As I said before, though, the vast majority of African Americans don't have sickle cell, and you can have sickle cell and not be an African American. But it is something that is fairly closely connected to that racial identification. So if an employer were to say, well, we're not going to hire people with sickle cell, that would definitely have a disparate impact upon the African American community. Also, sickle cell anemia can absolutely be a disability under the Americans with Disabilities Act, because this could, it probably would be a disability under that law, so there would be the need to reasonably accommodate people with that diagnosis. So if I had a client, let's say I'm an attorney who's representing, say, an African American with sickle cell anemia who's been dismissed from his job, I absolutely would pursue a race discrimination claim as well as a Americans with Disabilities Act claim. And again, this would fall into that kind of race plus idea. Let's talk about culture and perception. There is something that many times people will talk about, something like a black accent, and obviously there is no black accent. There are all kinds of different ways that we speak in different contexts, and so there are plenty of African Americans who have lots and lots of different types of accents. But identifying and saying, well, you happen to have this accent, so we don't want you, that's not lawful. Because unless your accent were so strong that people couldn't understand what you were saying, but that wouldn't ordinarily be the cause. So just because some people say, well, I prefer an accent other than the one you have, that your accent is not melodious to me or pleasing to my ears, that would be an example of discrimination. So black accent is not a basis to not hire somebody. You also can't discriminate against someone based upon their cultural dress, their grooming practices, or their accent or manner of speech. Now, this doesn't stop employers from having dress codes or things along those lines. So the employee doesn't have a right to dress in his or her cultural attire, but you can't prohibit that person from expressing their culture in other contexts. So let's consider this scenario. Bob is the owner. He never makes a black employee a supervisor because he believes his Asian work crew, most of his employees will say are Asian, will not follow the instructions from a black supervisor. Will this be a disparate disparate treatment case? Basically, Bob is saying, well, I'm not the bigot here. It's my employees who are the bigot. Well, no. Just like customer preference can't be a reason to discriminate based upon race, a coworker or subordinate preference is not a basis to discriminate. The black employee who's best qualified for the job ought to be the one who's put into the job if he happens to be the best qualified. And if members of his team are disrespectful or insubordinate to him, of whatever race they may be, then they should be disciplined for that. Let's consider the issue of association. In this scenario, when we talk about association, we're talking about when a person has a connection to members of a different race. It could be familial, family-oriented, roommate-oriented. Lots of different connections can exist. It can actually be others, though. It could be that you attend a church with individuals of predominantly a different religion. Different race. So let's say you are Caucasian, but you attend a largely African American church. Or perhaps you attended an historically African American college, even though you're white. And let's say you're discriminated on that basis in the employment context. That would be a racial discrimination by association. So in this example, we have Mary. She's Caucasian. She's married to an African American man. One day, her husband stops by the office. A few days later, Mary is fired for no reason. If Mary can demonstrate that the fact that the place of employment didn't like the fact that she was involved in a biracial relationship, then she has a claim for discrimination by association. Now, let's imagine the same workplace that there are lots of African American employees and they don't seem to have any problems in the workplace. And let's also assume that many of these African American employees are also married to other African American individuals. And there doesn't seem to be any problem with that either. The employer could make the argument, well, I don't have a problem with blacks and I don't have a problem with whites, but I do have a problem with biracial marriage. Well, that's an admission of discrimination under the law. It's not the employer's role to decide whether this person ought to marry this person or people of this race ought to marry people of that race. It has nothing to do with the performance of Mary's job responsibilities. So the admission that he fired Mary because Mary's involved in a biracial relationship is per se evidence of discrimination under the law. Let's look at some stereotypes. Bob is an African American with a law degree. He's hired as the first black attorney at a law firm. He handles routine matters very well. After a few months, though, Bob notices that he is not being given the sophisticated project that other people at his level are being given. So Bob isn't having the professional growth opportunities. He approaches the partners and says, I'd like more challenging work, and they basically give him the brush off. Under this scenario, Bob does have a basis for a claim of discrimination because he's treated differently. Maybe the law firm has racial stereotypes. Well, it's fine for us to have an African American attorney, but we want him to be behind the scenes. Maybe we want him for our brochure, so we appear to be progressive, but we don't really want to give him real work because we don't think African American attorneys can be as good as Caucasian attorneys. That type of offensive racial stereotypes, whether it's conscious or unconscious, would be discriminatory. In this situation, you might say, well, Bob hasn't lost any income. They don't seem to be upset with his work. Well, that may be true, but since Bob isn't having the opportunities to progress, when it comes time for the law firm to decide who to make partner, Bob won't have had the professional experiences that will put him in a position to be somebody who could make partner. So these actually are adverse employment decisions with respect to Bob. We obviously cannot segregate parts of the workplace, be they lockers, restrooms, recreational areas, or the workplace itself. This can come up not so much in the racial context, but in the national origin context with English-only rules. Let's say you have a policy in a facility that says, well, you know, in this break room, people can only speak English, but we have this other break room, you can speak whatever language you want. That could essentially segregate the workplace. A better policy would be to say, hey, when you're not working productively, you're on your break, you're on your lunch, speak whatever language you want, because that's your own time and you ought to do and spend that time as you feel most comfortable. So as a general rule, an English-only rule may be applied in the workforce only if it's needed for safety reasons or to make sure that the employer's business is run efficiently. Therefore, lockers, restroom, recreational areas are not going to cut it. And you definitely don't want to segregate the workplace. Let's say you have 2 assembly lines in your facility, and one you have maybe the African American population on, the other one you have the white population on. That would not be appropriate. You ought to just have, you don't have to intentionally integrate them or have some kind of, you know, white, black, white, black, white, black, any system like that, but you ought not choose where a person is going based upon their race, but based upon their skills and interests and the needs of the department. In the case of government action, let's talk about strict scrutiny. Under the 14th Amendment to the Constitution, there is, well, I mean, first of all, I'll talk about the 14th Amendment. As I'm sure you know, the first 10 amendments to the Constitution are called the Bill of Rights. Originally, those protections afforded to individuals under the first 10 amendments were just with respect to federal government action. When the 14th Amendment was passed during that Reconstruction era, so they were passed at the same time that we have Section 1981 and 1983. Anyway, the 14th Amendment included lots and lots of provisions. It's quite a long amendment, actually. But one of the things it does is it talks about equal protection under the law. It talks about due process. And so whenever the government acts, be it state government, local government, or federal government, it has to follow due process and equal protection. And so there's a rating system. There's actually 3 levels to this that the U.S. Supreme Court has developed. Sometimes the government makes distinctions based upon gender. Sometimes it's on some other basis, and sometimes it's based upon race. Well, the U.S. Supreme Court said, when it's about race, we're going to apply a strict scrutiny standard. In other words, it's going to be very, very hard for the government to be able to persuade us that we need to make distinctions based upon race. It's just very, very difficult for the U.S. Supreme Court is saying for us to imagine that's ever appropriate. This is what strict scrutiny means. Let's look at these 2 buttons here. A compelling government need must be shown for such a classification to be upheld. So a compelling government need. Also, the least restrictive of the ways of responding to that need have to be part of the plan, so it has to be the least restrictive. The bottom line is that almost always any kind of classification of people by race is going to be found to be unconstitutional. Almost is never going to work. I've seen it work maybe occasionally. Well, actually, I won't even say that. I don't think that does work. So just not a winning argument. Employees can sue under state or federal constitution for a denial of equal protection if they work for the government. But this argument, this constitutional argument, of course, is not going to work for private citizens. But of course, we're not going to see racial categorization in the private sector because of Title VII. So while you can't rely upon constitutional protections if you're a private employer, you do have statutory protections. So now we've talked about racial discrimination, including disparate impact, disparate treatment, association, and retaliation. think I'm going to end the lecture now, and we will complete this lecture in a subsequent, complete this talk in a subsequent lecture. As always, if you have questions about the material, please feel free to send me an email. My email address is cgroover@collin.edu. Alternatively, I would love to sit down and talk with you in more detail about these topics. I thank you for your attention, and I hope you have a wonderful day. Take care.